How to pass rental properties down to your family and avoid the probate process. The problem with holding these properties in your personal name is that when you pass away, they will have to go through the probate process. And they are effectively frozen when they go through the probate process. Your family will not be able to sell them to generate cash. They won't be able to access the cash flow. They won't be able to evict tenants who are not making payments. They won't be able to hire contractors to come in and do renovations during the turnover periods. And if a roof or an HVAC system goes out, they cannot hire a contractor to come in and make those repairs legally. And so it's effectively frozen during the probate process. And because you're sending a rental portfolio through the probate process, it's going to be more complex and the probate process will take longer, extending the time from them being able to access the money inside that rental portfolio. Now, it's very likely that you built the rental portfolio to take care of your family and give them financial stability in the event that you are no longer around. The problem is when you hold them in your personal name, you are giving them financial instability because you're having to send those rental properties through the probate process and not allowing your family to access them. Now, there are a couple of different ways that you can avoid the probate process with rental properties, and it depends on who you want to send those properties down to, how you're holding them currently, and that what you want to do with control on the back end. And so the different ways that you can hold it is joint tenants, rights of survivorship, tenants in common, or a revocable trust. Now, joint tenants or rights of survivorship will allow you to own the property 50-50 with another individual, typically your spouse. And then when one of you passes away, your half of the property will automatically be transferred down to your surviving spouse, avoiding the probate process. All that they would have to do is file a survivorship affidavit at the county clerk's office in the county where you live or where the properties are located. And then if you want to co-own those properties with your kids as joint tenants, rights of survivorship, so it avoids the probate and goes directly down to them, same thing. The problem is going to be when you co-own the property with your kids, you're exposing yourself to their liability. So they may go through a divorce, get into a car accident, have a lawsuit coming after them, or lose their job, not be able to find another one, and have creditors coming after them for not being able to make their payments. In the event that your child has those liabilities and you co-own the property with them, you will have to sell those properties to generate cash from the equity that they have in their half of the property to pay off those liabilities. So you need to make sure that avoiding the probate process is worth the risk that you're putting yourself through by co-owning the property with them. There are other ways that you can do that. One of them is going to be a transfer on death deed. So you'll be able to hold the property in your personal name, list them as a designated beneficiary on that property, and then when you pass away, the property will be distributed out to them. All they have to do is file a survivorship affidavit and the death certificate at the county clerk's office in the county where the property is located, and then they would take over ownership of that property. That way you maintain full control while you're alive. You are not exposing yourself to their liabilities, and then you're passing it down to them, avoiding probate. The last one's going to be a revocable trust. And so we can go two routes here. Whether you're currently holding them in your personal name or you're holding them inside of an LLC, the process is relatively the same. If you're holding them in your personal name, you would just transfer the ownership from your name into the name of the revocable trust. And then if you have the properties inside of an LLC, you would just assign the LLC membership to the revocable trust and then update your operating agreement so that your trust can actually own the LLC membership. And now your properties or the LLC is inside of the revocable trust. While you're alive, you can maintain full control over the properties or the LLC inside of that revocable trust. When you pass away, your backup trustee steps in your role as trustee, and they will be able to manage those assets on behalf of your family or distribute those properties or assets out to your family. And so what we like to do is keep the properties inside of the revocable trust and use those assets to take care of the surviving spouse for the duration of their life. And then when they pass away, because the assets are still inside of the revocable trust, they will be able to avoid the probate process when your surviving spouse passes away, and then you can pass them directly down to your family. That's how we like to set up. You can set up however you want. If you want help setting any of this up, click the link in the bio, fill out the form, and schedule a time to talk to some on our team.